Buckingham Palace or Prince William set a trap for Prince Harry and Meghan Markle, and were they gullible enough to fall into it?
He's had enough. He wants to clean the monarchy, and it's all now in the hands of the courts. Meghan Markle is in full mode panic along with Harry because they both know what they did.
The stories would come out. So apparently, according to other journalists, we found out that there were a lot of porcupines probably told to the royals and even to Harry when they met her, and in order to cover up.
It's actually torture to listen to that woman now, because every other word out of her mouth is a lie.
Prince William is reportedly drawing a firm boundary in an ongoing debate that has resurfaced around Meghan Markle's maternity story. At the same time that the Duchess has been sharing personal and lighthearted content from hospital settings on social media, please subscribe. It cost you nothing, but it truly so much to me. Including videos that drew strong engagement online, a separate legal development in the United Kingdom has quietly reignited broader questions about inheritance laws.
Maybe King Charles didn't want to do anything about it given what's going on with Andrew, but in order for William to save the monarchy, he has to deal with the Archie
surrogacy and how centuries-old definitions still affect modern families. A major inheritance dispute involving a British aristocratic family has recently reached the High Court in Bristol. According to legal reporting,
people think her kids are fake. They think they're AI.
I'm going to quote Tom Bauer by saying, he said, look, we all laughed at Samantha and she was right. And everything she said has come true.
Right now in the courts, which is incredibly important, and nobody's paying attention to it because this will make history, and not in a good way for Rachel Meghan.
The case centers on whether a child born via legally documented surrogacy qualifies under historic trust language that predates modern reproductive practices. The inheritance in question, reportedly valued at around £157 million, is tied to wording that uses traditional legal phrasing such as born of the body.
There's an article out there that Meghan had a hysterectomy and couldn't have children, and that was a big issue in their relationship. So that says a lot to the fake royal kids right now, because obviously they couldn't have come out of her. So that's something that she obviously is going to have to deal with.
A term embedded in property and succession law for generations. During proceedings, the presiding judge is said to have acknowledged uncertainty about whether the child automatically falls within the class of beneficiaries defined in the original trust documents. Legal experts note that cases like this highlight the tension between contemporary family structures and legal frameworks written long before assisted reproduction became common.
Had a lot of health issues and she couldn't have one of her children. So they had to use a surrogate in the United States. Why the United States? Because in the United Kingdom, the children, even though through a surrogate, belong to the surrogate.
Do you remember Meghan actually refused to use the hospital that was usually used by royals and refused to use all of the normal medical staff? And there was all of the weirdness over the timing of the birth of Archie.
Although the case itself is not connected to the British royal family, commentators in royal watching circles have begun drawing parallels. They point out that the principle of legitimacy in the royal line of succession has historically also relied on the concept of heirs being born of the body, language rooted in the Act of Settlement 1701, which still shapes constitutional rules surrounding the monarchy.
Marquess of Bath was open and transparent about this. So she is right now going through the legal process because as per the Peerage Act of 1963, that child born in the United States from a surrogate is not entitled to anything, inheritance or anything.
For centuries, royal births were highly formalized public events. Palace-appointed officials traditionally documented the circumstances of birth, and announcements were carefully structured to avoid any ambiguity about succession. This level of transparency, historians say, was designed not for spectacle, but for constitutional certainty. In recent years, however, and some observers have argued that royal birth traditions have evolved, particularly after Prince Harry and Meghan Markle stepped back from official duties.
Meghan Markle has been incredibly quiet about the birth, but mostly the pregnancy of these children. Everything has been shady. The one who's been blabbing and saying crazy things is Prince Harry.
The birth of their son, Archie, in May 2019 at the Portland Hospital in London marked a noticeable shift from past precedent. Unlike previous senior royal births, there was no immediate photo call on hospital steps and no publicly displayed notice signed by attending physicians, practices that had long been part of royal protocol. Prince Harry later described the experience in his memoir Spare, writing that the couple left the hospital relatively quickly and returned to Frogmore Cottage before formal confirmation of labor had even been widely circulated.
Obviously, when William was born and Harry was born and George and Charlotte and Louis, we got great pictures outside the hospital. I remember, and William and Catherine especially, they made such an effort to show the whole world their new baby. Baby was born. When Archie was born, that was another, in my view, a disaster because I knew we was not going to get a picture of it. Everybody was hoping we would get pictures of it.
Some readers viewed the account as a personal and modern portrayal of parenthood. Others interpreted it as an unusual departure from the traditional transparency associated with royal succession. Discussions intensified again after the birth of their daughter, Lilibet, in California in 2021. In his memoir, Harry described being physically involved in the delivery, a detail that many parents found touching. Yet constitutional commentators note that such personal narratives do not address the formal verification procedures historically associated with heirs in the line of succession.
We've had Harry on Spare talking about, how Meghan Markle, how complicated it was, how they went to the hospital, how Meghan Markle had to have 2 epidurals. We know all of that is BS. We know all of that is a lie.
It is important to emphasize that there has been no official evidence presented that questions the legitimacy of the Sussex children's place in the line of succession. Nevertheless, online speculation has persisted, fueled in part by broader debates about privacy, modernization of royal customs, and differing expectations about public disclosure. Supporters of the Sussexes argue that the couple has every right to handle family matters privately, especially after stepping back from royal life. Critics counter that when constitutional implications are involved, even indirectly, greater clarity can help prevent rumors from taking hold.
This scandal comes as no surprise. Speculation about the children has been simmering for years.
Silence everybody and just produce a DNA sample or proof of delivery. If you had those things, it would be very easy just to put them out there and say, this is what happened. This is what it is.
Legal scholars say the aristocratic inheritance case now unfolding may prompt renewed public discussion about whether historic succession language should be updated to reflect contemporary realities such as surrogacy and assisted reproduction. Some believe the monarchy and parliament could eventually face pressure to modernize outdated definitions to avoid uncertainty in the future. For now, the situation remains largely a matter of commentary and interpretation rather than confirmed controversy. As what is clear is that centuries-old legal principles are increasingly intersecting with modern social norms.
Meghan, a geriatric mother. The family claims and states that Meghan had a hysterectomy. How can a woman with a hysterectomy be pregnant? And most of all, why did the royal family go along with this? And what's going to happen now that this has come out?
And that intersection is likely to keep generating debate, both inside aristocratic courts and across the wider public conversation. The key question many observers are now asking is not only about individual cases, but about the broader future. How should institutions built on tradition adapt to changing definitions of family, legitimacy, and privacy in the 21st century? Unlike many significant royal births in previous centuries, the arrivals of Archie and Lilibet were not publicly documented in the same traditional manner that earlier royal births had been.
William knows that the crown cannot keep making the same mistakes in the past, that nobody who is not working royal can hold titles.
Historically, senior royal births were often accompanied by formal verification processes involving palace-appointed officials or publicly displayed medical confirmations. In the Sussex case, no such visible independent witnessing was announced in the traditional format. Some commentators note that modern privacy expectations and changes in royal protocol may partly explain this shift. Others argue that when children are placed high in the line of succession, transparency remains an important constitutional expectation.
At this point in time, King Charles doesn't understand that he cannot continue having Harry and Meghan on the British monarchy's website when they are absolutely trashing the very same institution and using titles for commercial purposes, which is basically repeating the same pattern that Sarah Ferguson has done and even Andrew did. That has to stop.
All of the privileges that go along with an identity, but she doesn't want any of the responsibility. She doesn't want to do any of the work. She wants the tiara. She doesn't want the public service.
From a legal and constitutional standpoint, personal accounts, including Prince Harry's own descriptions of the births, do not function as formal verification documents. For observers focused on monarchy traditions, this distinction has fueled ongoing debate. One question frequently raised in royal commentary circles is why no simple public clarification has been issued to address lingering speculation. While supporters of the couple say they are entitled to privacy and should not be pressured to respond to rumors, critics counter that a straightforward confirmation could help prevent misinformation from spreading.
And the Peerage Act of 1963 clearly states, just like for royalty, that a surrogate cannot be used.
According to various royal correspondents and unnamed sources cited in media discussions, Prince William is said to view the broader situation with concern. These reports suggest he has taken steps over recent years to emphasize institutional clarity around royal roles and branding, particularly as the Sussexes have pursued independent media and commercial ventures. Some commentators frame this as part of a wider effort to distinguish between working members of the monarchy and those who have stepped back from official duties.
And William has ordered an open investigation into Lilibet and Archie's birth because he knows that that cannot be hanging over the head of the monarchy, over his reign.
An online debate has also intensified around the continued use of royal titles in commercial or public contexts. Critics argue this creates mixed messaging, while supporters view titles as part of heritage rather than marketing tools. At the center of renewed discussion is a separate legal case involving the aristocratic Marquess of Bath and a substantial inheritance dispute. The case concerns whether a child born through legally recognized surrogacy automatically qualifies under trust language written long before modern reproductive technologies existed. The father involved has publicly acknowledged the circumstances and is pursuing legal clarification to secure his son's inheritance rights.
So many of them, and why it would have been so easy to be honest about who she is.
And legal analysts say this case highlights a broader issue. British inheritance law and trust structures do not always automatically account for surrogacy unless provisions are updated or clarified through the courts. During proceedings, the presiding judge reportedly noted uncertainty about whether the child falls within the defined class of beneficiaries. For legal observers, this underscores how traditional wording can create complications in contemporary family situations.
Started coming out, but we didn't know that she had told the royal family so many porky pies. So it makes sense. Oh my God, I've got to keep everybody away because if they start talking, the lies come out.
Some royal watchers have begun asking whether similar legal principles could ever intersect with constitutional succession rules. The monarchy's framework has historically relied on the concept of heirs being born of the body, language rooted in the Act of Settlement 1701 and later reinforced by modern legislation such as the Succession to the Crown Act 2013. However, constitutional scholars emphasize that no official legal challenge has been brought regarding the Sussex children's place in the line of succession. Any such issue, they note, would require formal parliamentary consideration rather than speculation in media or online forums. The discussion has also been amplified by past comments from Meghan Markle's half-sister, Samantha Markle, who has questioned aspects of the public timeline surrounding Meghan's life. While these remarks have circulated widely, they remain disputed and have not been substantiated through official findings. Observers note that the Sussexes' response to many allegations has often taken the form of legal warnings or statements through representatives,
in this case about whether you think the birth was real, whether you think there was a surrogate, whether you think Meghan was wearing a moon bump. The fact is, Harry and Meghan lied. Buckingham Palace lied on their behalf. There was a complete cover-up over the birth of Prince Art.
Rather than detailed public explanations, critics interpret this as evasive. His supporters argue it reflects a strategy to avoid legitimizing unfounded claims. Prince Harry's memoir, Spare, included highly personal accounts of family experiences and royal life. Some commentators have pointed out that while the book addressed many sensitive topics, it did not directly engage with rumors surrounding the births of his children. Others argue that memoirs are not intended to serve as constitutional clarifications. For institutionalists focused on the monarchy's long-term stability, the key issue is less about individuals and more about precedent. Future monarchs, including Prince William, are widely seen as prioritizing structural certainty around succession. Legal experts say the Bath inheritance case illustrates how historic legal frameworks can generate ambiguity when confronted with modern realities. Unlike private aristocratic trusts, constitutional rules governing the crown cannot be easily amended through individual petitions. Changes would require parliamentary debate and legislative action. If hypothetical questions about succession eligibility were ever formally raised, constitutional processes, rather than media speculation, would determine outcomes. At present, however, such scenarios remain theoretical. The broader debate highlights contrasting expectations around transparency. Some observers point to the Bath family's open legal strategy as an example of accountability. Others argue that royal families operate under unique pressures, balancing privacy, security, and constitutional duty. Public opinion remains divided. Longtime royal watchers who followed major historical events, from the wedding of Princess Diana to modern royal milestones involving Catherine, Princess of Wales, often emphasize the importance of clear succession protocols. Supporters of the Sussexes, meanwhile, contend that modernization inevitably brings new approaches and that rigid adherence to past traditions may not reflect contemporary values. Ultimately, historians note that the monarchy has survived numerous crises over centuries, including abdications, scandals, and public criticism. Whether emerging debates about privacy, legitimacy, and modernization represent a temporary controversy or a deeper institutional challenge remains an open question. For now, the central issue continues to be one of perception versus verified constitutional reality. As legal cases involving inheritance and surrogacy unfold in aristocratic circles, they are likely to keep fueling discussion about how historic systems adapt to modern society and what that means for the future of royal succession.